Today, we're unpacking a fascinating and honestly high-stakes legal friction hidden right inside China's patent system. Imagine this. You invent a brilliant new part for a machine, you do everything right, you patent it. But then a competitor starts manufacturing and selling your exact part, just entirely unattached from the machine itself. Have they infringed your patent, or have they just found the perfect legal loophole? Well, finding the answer to this exact problem led Chinese courts to create a totally unique judicial concept known as use environment features. And today, we're going to demystify exactly what that means.
Okay, let's dive right into this. We'll be moving through a 5-part journey today, starting with the legal friction, then defining use environment features, outlining the 4 standards of infringement, looking at some real-world case studies, and finally, wrapping up with strategic takeaways.
Section 1. The legal friction, enforcing the unattached.
To really grasp this topic, you have to understand that this is literally a cat-and-mouse game between inventors trying to protect their creations and infringers looking for the slightest, tiniest gap in the legal armor. For a long time, the gap they exploited was the physical space between a part and the environment it was actually meant to be installed in. Looking at the evolution of Chinese patent law gives us the perfect context here. You see, in the early days before 2005, patent applicants lacked drafting experience, so they often included unnecessary extra features in their claims. To help them out, courts used something called the redundant designation principle. Basically, they just ignored extra, non-essential features when deciding infringement. But, as you can imagine, this created way too much uncertainty. So in 2009, the Supreme People's Court established a very strict standard. But this strictness accidentally created a massive loophole. And that loophole forced the court to introduce our main topic today in 2012, the use environment feature.
So, about that strict standard established in 2009. It's known as the all elements rule. Under this rigid rule, if your patent claims feature A, B, and C, an infringer only gets caught if their product has A, B, and C. Pretty straightforward, right? But now, think about the loophole. What if your patented part is specifically designed to be installed onto a larger machine? Let's say feature C is the machine frame itself. Well, an infringer could just sell your exact part uninstalled. Because their product technically lacks feature C, the frame, they can legally point to the all elements rule and say, hey look, we didn't infringe. Let's move to Section 2, defining use environment features, the judicial wildcard. Faced with inventors losing protection due to this technicality, the courts had to get creative. They needed a way to uphold the strict all elements rule while still stopping bad faith actors in their tracks. And this brilliantly illustrates how they solved it. They basically separated structural features from environmental ones. Structural features directly limit what the invention actually is, its physical shape, its components, the material it's made of. Usage environmental features, on the other hand, indirectly limit the invention by describing where it lives, its background of use, how it installs, or the external devices it connects to. So, the formal definition of a use environment feature is a technical feature used in a claim to describe the background or conditions of use of an invention, indirectly limiting the scope of patent protection. Now, what's absolutely crucial to remember here is that you won't actually find this term anywhere in the text of China's patent law. Know why? It was born purely out of judicial interpretations by the Supreme People's Court to ensure patent holders received reasonable protection against clever circumvention.
Section 3. 4 Standards of Infringement, the legal framework. Now that we know what these features are, how do Chinese courts actually test for them during a trial? Well, theory and practice have given us a highly structured legal framework consisting of 4 distinct criteria. Let's walk through how these 4 standards map out, kind of like a sliding scale of proof. The already used standard is straightforward. The patentee must prove the accused product is physically sitting in the patented environment right now. Then there's the inevitable use standard, where the patentee proves the product must be used in that environment because it physically can't work anywhere else. Next, we have the usable standard, which is much lighter. Here, the patentee just has to prove the product can be used in that environment. Finally, the not usable standard completely flips the burden of proof to the accused infringer, who must prove their product physically cannot be used in the patented environment.
Now, what's really interesting about this slide is the reality of how courts apply these rules. Based on a sample of 64 cases where use environment features were recognized, a staggering 82.8% of cases applied the lightweight usable standard. This is incredible news for rights holders. It means that, overwhelmingly, Chinese courts are adopting a highly patent-friendly stance. You usually just need to prove your competitor's part is capable of being used in your patented environment, even if they never actually attach it themselves.
Section 4. Real-world case studies, the rules in action.
Abstract rules are great, but as always in this explainer, we want to see what happens when these concepts collide with physical objects in actual courtrooms. Let's look at 3 distinct cases. Our first case study is the foundational 2012 case that really started it all, the bicycle rear derailleur bracket. The patent for this bracket specifically included claims about connecting to a bicycle body frame. The accused infringer manufactured the exact same bracket but thought they found a brilliant loophole. They simply sold the bracket totally unattached to any bicycle. And get this, during the first 2 trials, the courts agreed with the infringer. Because there was no bike frame attached, they ruled the strict all elements rule wasn't met.
But then, the Supreme People's Court stepped in and changed the game. They looked at the bracket and declared that the bicycle body frame was a use environment feature. Furthermore, they apply the inevitable use standard. As you can see in this ruling, because the accused bracket was necessarily used in that specific bicycle frame, it literally had no other commercial or practical use, it possessed the feature, even while just sitting unattached in a cardboard box. The infringer was caught.
Our second case study highlights a critical limit to this rule. It involves an ultra-narrow V-shaped steel component. The patent claimed a very specific design, which included a notch cut into the upper end of the steel. The accused product was nearly identical, but it completely lacked this notch. Sensing they were going to lose under the strict all-elements rule, the patent holder desperately tried a new strategy. They argued that the missing notch was just a use environment feature.
Yeah, the court didn't buy it. They thoroughly analyzed the claims and determined that a notch cut into a piece of steel is a direct, physical, structural feature of the product itself. It doesn't describe a background, it doesn't describe an installation condition or an external device. Because it was a structural feature, the strict all elements rule was applied. The accused product was missing the notch, therefore there was no infringement. It proves that you cannot simply relabel a missing physical piece of your invention as an environment just to win your case.
Our final case study shows how the incredibly popular usable standard operates in the real tech world. This involved a patent for a barcode scanner. The patent claimed a scanner with a line that is connected to an external device, like a power source or a data hub. The accused infringers sold a scanner with the exact same connection cable, but, you guessed it, they didn't sell it with the external device attached.
So the crucial point is how the court ruled here. First, they confirmed the external device was an indirect limitation, qualifying it as a use environment feature. Then they applied that lightweight, usable standard we talked about earlier. They noted that the accused scanner had a port and a cable that could connect to an external device. It didn't matter at all that it wasn't currently plugged in. Because it was simply capable of being used in that environment, boom, it infringed the patent.
Moving to Section 5, Strategic Patent Takeaways, Prosecution and Defense.
All right, we've seen the legal framework and we've seen the real-world impact. Now, let's translate this into actionable advice. How does this analysis directly affect your intellectual property strategy in China? Let's look at it from both sides of the courtroom. If you are the patent rights holder going on the offensive, this framework is a really powerful tool. Your first step is to identify exactly what features the accused product is supposedly missing. Step 2, aggressively argue that these missing elements are merely use environment features, not direct structural ones. Finally, Step 3, leverage the fact that courts prefer the usable standard. Remember, you don't have to prove they're actively installing the part, you just need to prove their part is capable of being installed in your patented environment. It significantly lowers your burden of proof.
Conversely, if you find yourself as the alleged infringer, your defense needs to trap the patent holder back in the rigid past. Step 1, argue the missing feature is purely structural, just like that missing notch in the steel case. Step 2, if you can convince the court it's structural, demand the strict all elements rule be applied to have the case dismissed entirely. And Step 3, if the court does rule it's an environment feature, your best bet is to try and prove your product has alternative commercial uses and isn't solely dedicated to their patented ecosystem. But the most critical takeaway actually happens before you ever reach a courtroom. It happens during the drafting of the patent itself. You absolutely must beware of prosecution history estoppel. When writing your patent or communicating with examiners, be incredibly careful not to state that your invention must be used in one specific environment, unless it is absolutely necessary to distinguish it from prior art. The words you use today to describe the background or conditions of your invention can totally box you in tomorrow. Let's leave it there for today. The concept of use environment features brilliantly balances strict legal rules with the practical realities of enforcing mechanical and technical patents. It's a really delicate dance between claiming too much and protecting too little. As you evaluate your own IP strategy in China, you really have to ask yourself, is your patent truly protected by its structure, or could it be trapped by the very environment it was designed to operate in?